Hi, everyone. Welcome to episode 5 of Immigration Talk with myself, immigration lawyer John Khosravi, and my wonderful associate and colleague, Anna Sergeeva. Anya, how are you doing today?
Hi, John. I'm doing okay. Um, I didn't sleep through the whole night because of my kids. They got sick.
Oh,
So yeah. But overall, how
well,
you been?
I'm good. For those, like, before I had kids, if someone said that, I wouldn't really appreciate what that means. It's pretty much like torture, and it happens every like every week or every month. It's like being a parent is
It's
it's
always
just
something. It's always something, right?
always something. Well, speaking of, there's always something. Immigration, another thing that's always something, almost like a baby that has a lot of
Mm.
problems. We're going to talk about the immigration reform, part of the Build Back Better Act that President Biden is trying to push and pass the House. Some major points that you want to discuss. We're going to talk about the N-470. This is for people that want to get U.S. citizenship. They have a green card, but they need to spend time outside the United States, and they don't, and they want to still be able to get citizenship. And there's a thing called the continuous presence requirement, requiring you to like consistently live in the United States. The N-470 form is an exception to that, so we're going to talk about that. And then also widower cases. These are cases where you're married to a U.S. citizen, for example, and the U.S. citizen passed away. If you're the foreign person, can you still get a green card? Well, they have a program for that. We'll briefly talk about that as well. I had a couple of cases contact us about that. I thought it'd be interesting to talk about. So, Build Back Better. What is going on? What are some major things that you saw in the legislation?
Yes. So I read not the whole thing because the whole thing is like 900 pages, but what we're interested in, what concerns immigration. So I just wanted to notice this bill just passed the House on the November 18th, right? So it still has to pass the Senate and it has to be signed by the president after that. So it's not the law yet. Hopefully it's gonna pass. Hopefully it's gonna work because it provides a lot of opportunities to different people. So I would like to start with the major thing about this bill is that it proposes for all people who were in the United States who entered before January 1st, 2011, and through visa and overstayed their visa, or they entered without inspection, or was paroled into the United States. All these people can qualify under this act. And what they want to do is to give them parole. This, like, I don't know, Jordan, you can help me with right wording. What is like right explanation for this word? But basically, this is not green card, right? This is just some temporary status. I would say maybe something similar to TPS, temporary protected status, but it's not exactly. That's what it is. But
It's not full status per se. It's this weird thing of saying you could come in and be here temporarily, and it's this weird nebulous concept. It doesn't have it's not fully status either, because
right,
the term status has certain connotations to it too.
yes,
That
and it has limitations. So it's 5 years for the period of 5 years, or until September 30th, 2031, whichever is faster. And
yeah,
it's not automatic, so people would need still to file an application. There will be fee for that. We don't know yet what's the fee gonna be, again, if it becomes the law, right? And
mhm.
security and background checks too have to be completed in order for a person to receive this, to get this parole. So this parole will give employment authorization,
Okay.
so people will be able to work, they will be able to travel. The act does not specify what kind of documents it will it will be. Probably maybe it's going to be some advanced parole
Yeah,
in order for people to travel outside of the United States and come back. We don't know this yet, but employment and travel will be authorized, and the act specifically mentions that all these people will be able to obtain driver license. So
yeah.
it's a good
That's
thing
a
too.
big deal. Now, one thing you note is there's a lot of parts of immigration law that give permission to get driver's licenses. Doesn't always mean the local state DMV will permit that. Sorry, if you guys are hearing the dog barking. And then, yeah, parole is this nebulous concept. Probably it'll be an EAD AP combo or something like that. Work permit plus travel permission. But it's like
Yes.
a bridge that to go somewhere. Parole is intended to be kind of a bridge, but where's it going to go? We don't know.
Yeah, it doesn't provide any like lawful status or path to citizenship or even path to green card, from what I see, it's just gonna give undocumented people right to stay for at least this 5 or more years, because there is it can be extended up until September 30th, 2031, right? And maybe by this time, someone will get married, will get their green card through marriage to a citizen, right? Someone will some
Yeah,
other
sorry. You
immigration.
mentioned I got excited because we do a lot of marriage cases and people need waivers, but if they're going to be considered paroled in, all of a sudden for like U.S. citizen marriage cases, they don't need to do a waiver or consular processing. So that
I think they still do. I think they still do. There were somewhere they were mentioned about inadmissibility. Yes, that the person is not inadmissible. So good thing you mentioned that. So because a waiver is required when a person is inadmissible. For example, for criminal convictions, certain criminal convictions, right? For certain immigration violations and so on, right?
Yeah.
So for these people, it's not going to be an option. Who needs to get a waiver, right?
Yeah.
Yeah. So
Which is maybe 3 or 10-year bar people with those who leave to the consular processing. But one thing is, and let me know. I haven't read it myself, so if there's more stuff, let me know. But it's still Senate has to pass it, and as we saw in the last one, they didn't get it through. So even if something does come through, it could look completely different than what's here. And the Senate is its own beast. So we don't know what's going to come out, but it's important to be aware of this kind of stuff that's happening. It at the very least, work authorization for people is going to be helpful. And one thing you didn't note is the documentation requirement of people who are here before 2011. There's a lot of people who intentionally stay under the radar and avoid getting any paperwork of presence in the United States. For immigration, that becomes a major problem because later on, for deferred action, for if you're in court and you want to get, I think, cancellation removal, withholding removal, these kind of things, you need to show, some consistent presence in the United States or entry on a certain date, even for a thing called 245I. So the documentation requirement of showing physical presence in the United States is something you want to have, and because these regulations pop up, they're always backdated. And if you don't have proof of 2011, as you said, then you're not be able to use these programs.
Right. And I just want to go back to inadmissibility, not all kinds of admissibility, right? The act specifically mentions what kind of admissibility and will work and what kind of will not. So again, we'll not go into great details about it, right? It's not the law yet, but everyone has to be aware of that. And what else I wanted to talk about this act is that it provides for visa recapturing for both.
Oh, wow.
Yes, for both family visas and employment-based visas. So what is visa recapturing? A lot of visas every year go unused for different kinds of reasons, right? And this act proposes that all visas that were unused from 1992 through fiscal year 2021, they will put them back.
Wow.
Yes. And specifically, the act mentions notwithstanding the numerical limitations. So as probably a lot of you know, that every year there's only a certain amount of people that can come to the United States, right? So again, we don't know how it's going to play out, right? But it's a good thing. Around 400,000 visas, including around 220 family visas were unused during this time that I mentioned, and around 100,000 employment-based visas. So what does it mean in practice? It means that all family preference categories and all employment-based categories, we can see like huge move for them. And a lot of people will be able to immigrate faster to the United States. A lot of people who've been waiting for their green cards in line.
Wow. That's a big move. And I kind of see that part staying because it's, for a lot of people, it kind of makes sense. Now there's the backlog of consular processing, which is slowly opening up, we're seeing. So there's still like people might, the visa bulletin might come current for them, but getting an interview is going to be another story. But especially if they're in the United States, that's a adjustment filing, getting the EAD, and it's very interesting. And I could see that one's at least partially or something moving.
Not
Maybe
everything yet. It's not all the good news about this act, because usually people talk like, for example, other immigration attorneys, they talk about the first part, but they don't talk about this. So what else is in this act? Diversity visas, right? So they're talking about diversity visas here. All people who were not able to get their visas, who were 2017, 2018, 2019, 2020, and 2021 who were not able to get their visas because of proclamations, because of COVID pandemic restrictions, and so on. And all these people who were unable to receive interviews, but they filed their DS form to 60, somehow they might be able to get their visas back. Again, we don't know how it's gonna work, but this is amazing. Like for these
Yeah,
people from 2017, like almost 5 years ago, you already forgot about this green card, right? And
yeah.
now you might still get it. This is
Wow.
like, yeah, I hope it's gonna
Tremendous.
pass. It's gonna give a lot of opportunities to these people, and I hope it's gonna work out well. Another thing I wanted to mention, that this bill also um, provides an opportunity for those who doesn't want to wait in line for their time to come to immigrate. They can just pay and skip the line, depending on what depending on what category is that. For example, for family preference categories, again, I will not go into details, but it's just general information on what's in the act. So there is supplemental fee of $2,500. For EB1A, EB-C, EB2, EB3 categories, it's $5,000, and for EB5, it's 50.
Interesting.
Yeah.
Very interesting. Wow.
Yes. So it's a lot of good news, a lot of information.
I'm always the bearer of bad news. They did pass a law for paying extra for expedited processing of cases or premium processing, which included work permits. And that was
Right.
passed a law a year and a half ago, 2 years ago, and USCIS still has not implemented it, even though they passed a law. So even though these things pass, they might drag their heels on inputting it. And so,
Right.
but at the end of the day, there's so much going on here. It's going to
There is
dramatically
special
alter.
implementing provision in this act, right? And
Oh,
thank
really?
you, John, for reminding me to talk about it, right? So it says that not later than 90 days after the date of the enactment of this section, Department Secretary of Homeland Security shall publish final rules implementing
Wow.
this section. So they
Wow.
thought about that too.
Yeah, they learn from their mistakes. Wow, that's great. So interesting. So that's going to be a good Thanksgiving, Christmas. I mean, I'm not sure when the Senate gets it. They're probably going to take breaks right now for the holidays and stuff, but we'll keep an eye on this and see what happens. Are there any more stuff you want to mention? But it's like, it's
Well,
kind
I
of blown
think,
my mind. Like, oh my God, this
yeah,
is kind of.
it's a lot of information. Maybe there's something else to it, right? Again, I didn't read through the whole thing, but what I was able to read through, it's already in and of itself very, very good news for a lot of people, for people who are in the United States, right? For people who are outside of the United States, for example, brothers, sisters, right, of the US citizen who've been waiting for their green card. Now it's it's like 15 years wait, right?
Yeah.
So somehow maybe they will be able to immigrate faster. Yeah. So
Very interesting. For these brother and sister cases, I've had times where people contact me and I say, well, it's 15 years. And I go, it's too long. But that's the importance of just filing it and getting your place in line, because the rules change and things could, move up and you never know. So, and I've had cases where people come to me and like, yeah, 15, 20 years ago, we filed it and we forgot about it. We just got, notices from the National Visa Center to start the case. So it's always good to start these. It seems like a long time, and it is a long time. But again, we started about talking about having kids and stuff like that. Time flies. These kids grow up and families grow up. And the great thing about the brother and sister kind of green card case, F4 preference category, is you apply for your brother and sister, but a lot of times they're older. Immigration is not the smoothest thing for them, but they're really doing it for the children, so they can leave the countries they're from and get a better education system, a more free society. Frankly, both of us from countries who kind of have lockdowns when it comes to speech and stuff like that. People want to raise their kids in an environment that's more, open to, thought and opportunity, economic opportunity in particular. So these brother and sister cases, file them, and if there's this opportunity to pay some extra money, you get it done faster, and that's going to be wonderful.
yes, but this option of skipping the line, right? It's gonna work from what I see. It's gonna work for adjustment of status. It's not gonna work for the like visa processing, at least from what I see now. Maybe something will change, right?
Yeah.
But still, it's a good option.
Because we had during Trump's time where they're going to take away the brother and sister case and potentially saying, if you already had a case pending in the new system we develop, you're going to get extra points. So that's why, again, it's like, we don't know what's going to happen with the law, but it's better to have a place in line than not, because you never know. So it's a fast moving kind of thing. We'll see what the Senate does, and then they're going to change things up, goes back to the House, and then they have to negotiate things. But we'll be on top of it because it's a game changer. I mean, 2022 could be a whole new world for immigration. The consulates and embassies open up. We have new rules. I mean, a couple years of Biden in there, so there people are coming into USCIS and State Department as opposed to the Stephen Miller gang, the previous anti-immigration crowd. So there's a lot of things that could change, when pandemic calms down. So thank you for that. That was a good start to the morning. We're recording this. Very interesting kind of stuff.
You're welcome.
So, the next thing I want to talk about is, well, you get the green card, you come to the United States. There's a requirement to be able to become a U.S. citizen that you have to be here for a certain amount of time. Now, I did an in-depth video, Nika, on YouTube, check it out. It's about citizenship timing requirements. There's various types of them, but one of the main ones is continuous presence. It means you're going to be, you're living in the United States without having gaps outside of the United States. And for most cases, unless you're married to a U.S. citizen, it has to be for a 5-year period. You shouldn't have any gaps of more than 6 months, or really not even multiple gaps of 5 months. But sometimes we have clients who are in the United States working, and all of a sudden, for example, their employer says, I need to move you to Canada or Europe to work for 2 years on a project. And that becomes really dangerous because they're like, well, I want to accumulate my continuous presence. I don't want to break my continuous presence to be able to file for U.S. citizenship. What can we do? Well, there's this option called Form N-470, which says if you are, want to keep your continuous presence okay, you apply for this form. And if you're working for what's a U.S. located company that's majority owned by U.S. people or U.S. stock owned, then you could, in the furtherance of U.S. trade and commerce, go for the company abroad. Now, it gets very technical because we do have to make sure that a company is a U.S. company, or if you're working for a subsidiary, they're actually a subsidiary, and your work is continuing trade. But the one problem that really gets 99% of the cases that I get, except for recently, COVID stitches up, is one of the requirements is that you have to have a whole year, 365 days physically in the United States before you can apply for an N-470. And most of the cases that get denied don't know this requirement, and they submit because they went on a 2-day vacation to Mexico, to Canada. They flew back home for a week, and that breaks it. So this 1-year requirement, very rarely were clients that came to me able to satisfy it. But with COVID and the lockdowns, all of a sudden we have a lot of people calling saying, oh, I have the 1-year requirement. We can pull it off now. And my company needs to send me to Canada, to Bahrain, or some random kind of places. So it's a really interesting thing for N-470 to do, and somebody to look into. Now, there's other requirements of physical presence, like you physically have to be in the United States for a certain period of time. This form does not get around that or undo it, but that continuous presence, saying you're consistently living in the United States, it's a kind of a forgiveness. And if the primary person gets it, their spouse and kids also get it automatically. Very interesting program that exists. I just wanted people to be aware of. Wants to get their green card, because a lot of times they have to go back and travel, or different things like that. So I thought it was a neat thing to talk about.
I just want to mention one extra thing about it, is that even filing N-470, and if a person, a lawful permanent resident, knows that he or she will not be able to come back to the United States, will be out for 1 year or more, they still need to file for re-entry permit. Right?
Yeah, so they could have the extended period of time could always lead to abandonment too. So it's safer to file for the re-entry permit to avoid from that happening. And that's what makes these things so complex. I still tell clients, if you can, try to fly back every 5 months, just to not to break that for the LPR, because what we're focused on the N-470 is for citizenship, but maintaining a green card could be something completely different. So there's different things you're doing here. One is for citizenship, one is for maintaining a green card. So always, if you feel like there's going to be extended absence of a year where you're not even going to visit the United States, always safer to do the re-entry permit, because who knows, you might go overseas and then you're working at this job that's N-470 qualified too, but then you get a better job overseas and you're working there. You might quit that job and the N-470 goes away and you forget about the re-entry permit. So that becomes an issue. And also one thing you have to be mindful of in the N-470 is you should never file your taxes as a non-resident. So this becomes a problem for the re-entry permit and for your green card for citizenship. If you go out and claim I'm a non-resident, you're essentially saying I'm abandoning my green card. So that could lead to a green card being taken away, N-470 being denied, re-entry permit being denied, and citizenship being denied. So you still got to pay the taxes. And it's just, you always have to pay federal taxes, but then it comes to state taxes. And so, you might move to a state like Texas, or Nevada, that doesn't have state taxes. So at least it alleviates that, as opposed to California. That's something you should talk with an accountant about. But there are different layers to this. So if you are interested in, moving out and you got some of the requirements, that's something to definitely talk with the immigration attorney about. Email us at info@jqqlaw.com. We can discuss in more detail. But there's a lot going on there, but I thought it'd be important to share because I'm getting more and more people who satisfy the requirements as opposed to before because of COVID, some positive part about it. So I definitely thought we'd mention it. So, there's another situation that pops up too, again, with the green card option I want to talk about. And unfortunately, we're getting a lot of this is widower cases. And, widower is, a person whose spouse passed away. And they have an exception that says, listen, like if you had an I-130 adjustment case pending, or you just didn't even have a case pending, you're both overseas, and your U.S. citizen spouse dies, the foreign spouse can still get a green card as long as they don't remarry and request it within 2 years. If you have an I-130 pending, it automatically converts what's called an I-360 widower case. Or if you don't, you submit an I-360. Many times, if you're overseas, you send it directly to the embassy. Or if you're in the United States, you submit it there with your adjustment of status application. So people have to be prepared. This widower case is an interesting thing that exists. It gives you options. It's just you got to act fast. I know in a period of mourning after someone passes, you're not in really the mindset, but you have a 2-year time frame to get it started. So that's to really give you the ability to come to the United States and have a green card. It's relatively straightforward, unless every case has its own nuances. For the most part, it's not the most complex thing, other than just, you got to go and think about something that's really emotional and get paperwork and death certificates and all this kind of stuff. But it's doable. So it's something I wanted people to be aware of as well, of these various options. If you're interested in learning more, just email us at info@jqqlaw.com. Let me know if you have comments about that, Anya, or
just two little things. Just two little
Please.
things. First thing is that it's gonna work only if you are married to U.S. citizen, not the green card holder. First thing to be aware of, right? And the second thing is that you have to be actually married. You have to be in a valid official marriage.
Exactly.
Yes, we talked with John recently about the issue. What happens if a couple, they were not married but they live in a state that recognizes common law marriage? This is a very interesting topic. Probably, I think it still has some room for arguments in this situation.
Yeah.
But if you find yourself in this position that you were not married but you lived in a common law marriage with a U.S. citizen, maybe there's still something that the immigration attorney can do for you.
Yeah, that's such an interesting thing you mentioned. We're talking with a colleague from New Jersey, and states like California and New Jersey do not recognize common law marriages. And the old thing was, if you're living with someone for an extended period of time, essentially they'll consider that being married. But California does not recognize that. Some states do. You could potentially, if you're living in a state that does, or maybe in another country that does in some way, you could argue that although we didn't get a marriage certificate, we are recognized by our home country laws or home state laws as being married. And that's an argument to make. It's going to get tougher, and you might need extra legal work for that. But we unfortunately have a lot of people who were together for 10 years, even have kids together, multiple kids. They just never did the act of getting married for some reason. And then something like this happens, and they're out of luck many times. So you should definitely look into getting married. Don't put it off. It's simple enough in the United States to get married. Getting married overseas has some headaches, but here is just show up at the courthouse a lot of times and you're done. So that's something I'm glad you mentioned that, because we do run into that issue frequently enough. Now, I like to keep it open at the end to discuss some stuff. We have a case right now that's a person that really needs to come to the United States. I want to go into the Humanitarian Parole B2 visa case and stuff, and just have a couple minutes talking about that. So there's a vast number of people, particularly from Afghanistan right now, who have applied for a thing called Humanitarian Parole. This is just permission to be able to enter the United States, similar to the parole discussion we had earlier, but just to be able to enter and then figure it out from there. Now, we've had, like, in the last month or two, 28,000 of these applications, mostly from people from Afghanistan. And from reports coming from news sources, only like 200 have been approved. So this is something that we're getting calls every day. I get emails from people from Afghanistan in particular wanting to do humanitarian parole. It's not something we actively do unless we have more work with a client or other options available. Just purely, we don't necessarily do that. But it is something that our firm partially handles depending on the case type and the facts that exist. But, the opportunity to just apply for a B1, B2 tourist visa exists. Most likely you won't be able to get an interview in many countries just because they're closed, or it's going to be denied. But that option exists. It might be faster than humanitarian parole if it's proved, as opposed to humanitarian parole, which doesn't really have a timeline. It has additional fees. So you want to mention any points about what humanitarian parole is, Anya, what we're dealing with in that one particular case, without going too many details?
Yes, so humanitarian parole is is an option for someone to come to the United States who otherwise, for example, inadmissible, right, or was refused a visa, but they still need to travel for some sort of humanitarian reasons. Yes, can probably benefit. It can be to receive medical treatment or to care for someone, a relative in the United States who is ill and requires care. There are different options about it. Generally, before this situation with Afghanistan and these poor people who have to file, they have no other option but to apply for humanitarian parole. And as John mentioned, already 28,000 of these applications have been filed with the USCIS, and it's only one department there who deals with this kind of stuff. And they're overwhelmed, right? But before all that, usually it would take around 4 months, I would say, to get the humanitarian parole either denied or approved, plus the time for the embassy processing, because a person still needs to go to the embassy in their home country or some like other country, right, to get this like stamp in their passport. It depends. It might be stamp, it might be like piece of paper, right? So like 4 months plus. But now it might take so much more time because USCIS is understaffed and they don't have all the resources just to deal with that many humanitarian parole applications.
So it's not a game changer where you pop it in and you get it. Now you can submit it with USCIS. There's a form for that. If you're at the border, you can make a request at the U.S. border, Mexico or Canada. There's less of those, but it is possible. I've had colleagues do that before. It is just a backup option that we have as a backup of a backup. Because of the delays and because how subjective the adjudication is, they may or may not do it. It's not something I'm very hopeful on and put a lot of weight into it, but sometimes that's all you have and you got to do it.
Yes, and if you're applying for humanitarian parole, definitely seek an attorney help, immigration attorney help, because it has to be extensive evidence has to be provided along with the application in order for it to get approved. So usually it's like medical records, right? It's affidavits from family members, from the person applying, from your citizen. There should be a sponsor too. I call it sponsor, but it's a person in the United States who will sign the I-134 form, saying yes, I'll take care of that, all the financial part. So there are a lot of details about it, but it's a good option, and we would like that more people learn about this option. People who were denied visas, but they still need to go to the United States, and this might work for them, depending on the reasons.
Exactly. Well, thank you, Anya, so much for coming on the show again and talking with us. Really good information. I'm glad you read some of the rules for the Build Back Better Act. It was very interesting, eye-opening. If anyone's interested in contacting us, just email me at info@jqklaw.com. We'll schedule a consultation, talk about your case, see what's going on there. Just email is the best way to do it. I guess until next week, everyone, God bless, be safe, and see you then.
Happy Thanksgiving. We're recording this episode 2 days before the Thanksgiving, so probably it's gonna be on YouTube after November 24th. Yes, but happy Thanksgiving all.
Thanksgiving. I'll see you all, and then after that, I guess the next one's going to be in December, so we're closing out November. All right, bye everyone. Thank you, Anya.
Bye.